You can go ahead, Karen.
Good morning, everyone. I would like to begin by acknowledging that we are in Treaty 1 territory and the traditional homeland of the Métis Nation. My name is Carrie Linklater. I'm your chairperson today, and I am joined on the panel by Mr. Mark Bareski, Mr. Maurice Theron. Our city assessor today is Mr. Jamie Forget, and our admin secretary is Michelle Neepin. We will be hearing applications for revision of the assessment roll in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application, and we will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparison of assessments of properties are not considered evidence of market value by the board. The board is appointed annually by City Council and is independent of it and the city administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the board's decisions with respect to an application may be appealed to the Manitoba Municipal Board. If the matter pertains to assessed value or classification, go to the Court of Queen's Bench. If the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with the board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions that the applicant may have, and then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all of the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applicants have been heard, and the board will deliberate in private and make its decisions. You will receive the board's decision by registered mail as soon as possible. And as information, all public hearings are live streamed, recorded, and will be part of the public record. Use of cell phones is not permitted except by the approval of the chair. You'd like to swear? Okay. Mr. Forget, we'll start with you to swear you in.
Sure.
Okay. Can you state your full name, please?
Jamie Forget.
Do you affirm that the evidence you're about to give at this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Neufeld, he's got his sound off. Hang on.
Got me. You can swear me in. No, thanks.
Okay. Can you state your full name, please?
Eric Neufeld.
Do you affirm that the evidence you're about to give at this hearing shall be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you. Mr. Mercury, can you state your full name, please?
James Mercury.
Do you affirm that the evidence you're about to give at this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Is that everybody?
Yeah.
Okay, perfect. Good morning, everyone. This morning we are looking at 761 St. Mary's Road, and there appears to be a non-co-op on this property.
Right. So if I can get started, the business assessment ID here is 43354. This is 761 St. Mary's Road. And as mentioned, there is a request request for the non-cooperation penalties and for the deferral. You can see on second page of my brief, we have the letter that was sent, as well as the third page. And then you can see on the fifth page, the tracking and the envelope that was sent. And then finally, on the last page, the signature. And it says that it was signed by C. Asen. And that's Coralie Asen, and that's the business owner as well. So they're the same party. And so this practice has come under some scrutiny lately. There's a board decision from the municipal board that I expect will be discussed today or referenced. It's been our practice that in cases where it's owner occupied and we can show that the business owner received the mailer request and did not submit an INE in time. It's been our practice that we've been asking for the penalties to be applied, and generally that has been done. As I say, there is a case, a municipal board case that will likely be referenced. Within it, there's some complications, but the board does acknowledge that we have the power under the legislation to request for the penalties for business assessment. But from there, it gets a little bit more complicated. And I expect Mr. Mercury and Mr. Neufeld to maybe expand on some of those complications. But as I say, we are under a directive to consistently request the penalties out of fairness to other properties who have had the penalties apply in a similar manner. So with that being said, we are requesting the penalties. Thank you.
Thank you. Panel, do you have any questions at this time of Mr. Forget?
Yes.
I do. It's Morris. You hear me?
I can. Good morning.
Hi, good morning, Jamie. You mentioned submit in time. Does that mean that there was an issue of timing here? Because you mentioned that and some complications, but the submit in time, could you clarify that, please?
Sure. To be clear, we did not receive a mailer back for this year that we're referencing here for 2017. And the penalties were applied to the realty at the realty appeal as well for the Board of Revision.
Okay. So it's not a matter of timing, it's a matter of not receiving it. Is that it?
Correct.
Okay. And the complications, I guess we'll get it from the appellant, I guess, and then we'll see what these are. Are they too difficult to explain at this point?
Mr. Mercury had the benefit of being party to that hearing, and so he may be. I might defer to his explanation and interpretation on those. Specifically, it results or it centers around the inclusion of a business assessment roll number in the mailer. That's what the municipal board in their order. This is on the hydro business assessment, and the decision was relating to, in part, the penalties and their applicability to business assessment. And the order does say that legislatively we have the right to seek the penalties. However, it also mentions that there should be a requirement for business assessment roll numbers to be listed specifically in the mailings that we send out for income and expense questionnaires. That has not been our practice. And, some questions I think within our department maybe still exist as they relate to that. But since we have not deviated from our directive to this point, and out of the interest of fairness, and from my perspective, to keep it simple, we're asking that the penalties apply here as they have been previously.
Well, there seems to be some hesitation on the part of the assessment division to apply this penalty. That is the impression I'm getting from what you're saying is I don't know if that's fair. I'm just trying to go on your evidence here.
Right. So I wanted to acknowledge that this order exists, and that this order, when viewed in its entirety, makes things more difficult to follow to the letter of the order. But it is our policy and it's our directive to request the penalties here. And we are firm on that. I did want to be upfront about this order. And as I say, I think Mr. Mercury and Mr. Neufeld have some points that they would like to discuss with regards to that.
Okay, thank you. That's fair. I'm just trying to get the lay of the land from the assessment division before we hear the appellant. That's all.
Certainly.
Yeah, thank you.
Thank you.
Thank you, Maurice. I do apologize. Sorry, Mr. Mercury, you should have had the opportunity to ask questions first. So you go ahead. Thank you.
Okay, so just a few questions. Just at the outset, Mr. Fougere, you indicated that the decision to request the penalty is not yours personally, but instead a directive, I assume from your supervisor, to request it in all cases. Is that correct?
Correct.
All right. Just looking at your brief for the moment, the first page of the brief indicates the business assessment ID, which is the roll number, correct?
Correct.
That's 43354.
Correct.
And that, of course, would be different than the realty assessment roll number.
Correct.
Right. So if we look at the next page, the letter, the mailer itself, which is dated June 8th, 2018. And is there any reference to the business assessment roll number on that mailer?
To be clear, there is not.
Okay. And then it references the property address of being 759 St. Mary's Road, not 761. Am I correct? And I'm just looking at a map here that there are actually two occupants of that property, 761 and 759. Is that correct?
Correct.
So would there be actually a separate business assessment for, I believe it's a hair salon in 759 St. Mary's, is that right?
Yes, indeed, on both those points.
Okay, so this mailer is addressed to 759 St. Mary's. We're dealing with 761 only for the business assessment purposes, correct?
Correct. And as that relates, I will note that the mailing address, just for clarity, is 761 for the income and expense questionnaire. The entirety of the property, both units, are called 759 St. Mary's Road. 761 is the unit that the owner-occupier occupies.
Right. So, but just to summarize, there's no reference in this mailer at all to the business assessment specifically, correct?
Only indirectly in the form of the tenant verification page.
And this is a fairly standard form letter that would have been issued at the time in 2018 to all businesses in the city of Winnipeg, correct?
To all property owners.
To all property owners, correct. And you referenced the Manitoba Hydro decision, which of course I'm familiar with, we'll turn to in a moment, but I'm assuming that the mailer that was sent in that case would have been an identical form to what we're looking at today. Okay. All right. And have you had a chance to look at that decision, Mr. Fougere?
I have.
All right. And you're aware that it indicates that one of the reasons for denying the penalty request or deferral request in that case was the fact that there was no reference to the business assessment roll number, and it wasn't clear to the taxpayer that they were requesting information for the purposes of the business assessment.
In terms of it, whether or not it was clear to the specific owner, I can't comment on that, but the issue as it relates to not explicitly mentioning business assessment and not including the business assessment roll number, that is true.
Okay. And in fairness to you, I'll refer to that during the course of our submissions, but it appears you're familiar with it, and your position here today is that you're following direction to request the deferral order. Is that a fair summary of your position?
Correct. I think our department would require further clarity and time to fully take under consideration all of the information and sort of outlining of recommended procedure through the order to be able to follow it with regards to our process for income and expense questionnaire requests. And furthermore, there are previous cases as well where this has not been an issue. So our department is standing pat with what we've done previously and to remain consistent.
Okay. When you say this hasn't been previously an issue, to be clear, are those cases subsequent to the Manitoba Hydro decision and subsequent to argument of the Hydro decision?
I'm not aware. I would think not. And to clarify what I mean when I say that, I've been unaware of the necessity for the inclusion of a business assessment roll number in a mailer submission.
Okay, and that's fair. You're just going off your current knowledge base. So those are my questions. Thanks very much.
Thank you. Mr. Boraski?
Your letter sent out, and I assume that this is standard wording, correct me if I'm wrong, but I'm assuming that it is standard wording in all of these requests where it says the City of Winnipeg Assessment and Taxation Department is collecting information for the purpose of preparing the next general assessment. What is included in a general assessment then?
So the general assessment includes, of course, the reassessment of all properties in the City of Winnipeg, specifically commercial, and then within that, specifically retail. And then within that, as a sort of companion assessment to the realty, we have business assessment, and that is part of the general reassessment.
So do you take this then as notification that this is being collected for the purposes of preparing the realty assessment, the business assessment, and personal property assessment rolls? All three?
Correct. And the reason why I do, beyond this language here, is calculation-wise, the business assessment and the realty are really enmeshed together in the same system that we work through, and the collection of that data is one ultimately, and generally with a few instances where there may be extenuating circumstances, but generally what goes for the realty in terms of a rental rate and an area also goes for the business assessment. So they cannot be fully separated, and the general reassessment certainly includes business assessment.
And if something is being requested for a property identified by a specific roll number, is that information used elsewhere other than for the very specific valuation of that property?
Certainly. So it goes into our database for the model and for modeling purposes. It goes into a database to pull comparable information in order to support assessments or recommendations or agreements at the board of revision and the municipal board level. So it really is, the data that we collect really is at the heart of everything that we do. And the two primary things that we do are the realty assessment and the business assessment, both of which are part of the general reassessment.
Okay. Section 16.1 of the Municipal Assessment Act allows you to request this information. And it says that you can request it and the person has to provide it to the assessor. Information or documentation that relates or might relate to, or that affects or might affect the value of the property being assessed. With business assessment, is there a value, and does this word value relate to the business assessment as well as to realty and personal property assessments?
Right, it does. And the municipal board order that has been mentioned, the hydro business assessment municipal board order, which I believe was sent out this morning as well, specifically mentions that the language in the act surrounding value does apply to business assessment value or annual rental value, as we describe it. And so the board found that legislatively we are supported in our request for the information and therefore the penalties to apply to business assessment.
Did the municipal board find that the property they were dealing with was owner occupied, and that had a bearing on the answer to whether the non-co-op was to be applied or not?
It certainly was owner occupied, and in this case, with this property, it's one of two tenants, but the business assessment appeal that we have for us is owner occupied. So that's similar in that regard, that they're both owner occupied, and that's part of the reason why we ask, is because the party that received it is the owner of the business and the owner of the building as well. If it was sent to just a business owner who wasn't the owner of the property, that wouldn't be appropriate, because ultimately we're asking for information on the entirety of the property. So that's why we're applying it in this case.
Correct me if I'm wrong, but I think that decision said that because it was owner occupied, therefore there wasn't rental income. It makes it more questionable as to whether the non-co-op should be applied in this case. I might be recalling this incorrectly, but
it does say that.
Case, is this different because one of the two units actually does have rental income?
That's certainly would give us some more information, especially when we're trying to apply a business assessment to to the subject that's before us here, to have that comparable information of the neighboring unit is helpful, certainly, in cases like this. And you are correct that the order does specifically say, given the nature of the unit in the hydro building being owner occupied, it would be of limited value for what would be returned in terms of a rental rate as it relates to the business assessment.
That's all my questions for now, Madam Chair.
Thank you. I just have one question, Mr. Forget. Has this been a habitual issue of not providing information?
Specific to this property, I don't know that. I think I may have seen another year, but to be honest, I don't think it's been something that year after year they don't submit anything. I think that they have submitted in the past.
All right, thank you. And Mr. Neufeld?
Yeah.
Sorry, I'm assuming that did you have any questions?
No, not myself.
No. All right, thank you.
I'm letting the Aikens handle this.
Mr. Mercury?
I think all of my questions have been addressed. So if we're ready to present,
Yeah.
I can go ahead.
Yeah, you'd like to proceed.
Yes. So let me just start by asking if everyone has a copy of the hydro decision. The municipal board.
So it takes a little bit of time to scroll through it.
Okay. Sorry, you all have it?
No, I
Yeah.
don't. I'm sorry, James, I don't have it.
You don't have it? Okay.
I've got a problem with my email this morning. I don't know why, but so
Okay.
I don't have it. But that's okay. I'll listen and I'll listen closely and I'll rely on my colleagues. Thank you.
Okay. Well, I'll try to hopefully summarize it well for you and just read the relevant excerpts of it. So just to begin with, it's a little bit interesting that we're having this discussion today because my view is that this has been an issue that has been conclusively resolved by the municipal board in the Manitoba Hydro case. And in fact, we've had a couple of subsequent decisions from the Board of Revision on this, in which I was involved, and I could refer you to, where those two Board of Revision orders followed the hydro decision consistently. So what did the municipal board decide? What was the issue in the Manitoba Hydro case? There were two issues there. Number one was whether the deferral penalty, if you will, can apply in the context of business assessments. And number two, whether on the facts of that particular case, the assessor had established from an evidentiary point that there had been a failure to comply with a valid request for information under the Act. So there is no dispute that in the Manitoba Hydro case, the board did conclude that the legislation does permit a deferral order to be made in the context of the business assessment. That's not disputed. So that issue has been resolved, and that's not being argued today. The second question is whether or not the deferral penalty should be applied in light of the information request that was made. There are other issues that may arise in terms of service requirements, etc. One of the reasons why the municipal board declined to order the deferral penalty in the hydro case was having regard to the actual mailer itself. And so for those who have a copy of the decision, I'm looking at page 23 of the decision, and I'll just, for for those who don't have it, I'll just summarize it and read the relevant excerpts for you. This is at the bottom of page 23. In order for the board to make a determination of non-compliance, the board must be satisfied that a proper INE request was made and found its way to the owner. The burden of proof is on the assessor to establish these facts. As to the sufficiency of the first INE request itself, the board notes that realty assessments and business assessments are designated separate and distinct roll numbers. The Board of Revision orders and evidence show the 2016 realty assessment roll number as, and I won't read it out, and the 2016 business assessment roll as a different number. The distinction in roll numbers is reflected in the language contained in the first INE request, where the taxpayer is instructed to submit separate questionnaires for each roll number. The board further notes that the subject line of the first INE request refers only to a single roll number, which is the realty assessment roll number for the property. There is no separate business assessment roll number identified anywhere in the document. And then if you go to the next page, in the middle of the page, the board notes that even if it was established that the INE request did find its way to the owner, the board finds that the first INE request lacked any reference to the applicable business assessment roll number, and it was therefore not clear on its face to properly convey to the owner that the assessor was specifically requesting information pertaining to the business assessment. And so on that basis, the mailer that you have in front of you today, as Mr. Fougere correctly acknowledged, is identical in form to the mailer that was used in the hydro decision. And I will add to that, so you will note that the roll number on the mailer is strictly the realty assessment roll number, not the business assessment roll number. There's no reference at all to the business assessment. It also refers to 759 St. Mary's Road, which for business assessment purposes is in fact a different unit altogether. The assessor has the right to request specifically for business assessment purposes, if they wish, information directly from that tenant or occupier. They choose not to do so. So this clearly, on the basis of the hydro decision, if we want to be consistent, this mailer is insufficient. Now, going forward, this is not a complicated matter to correct for the next assessment cycle, for the next set of mailers. The city assessor can easily remedy this going forward. But in light of this decision, it's troubling that the assessor continues to ask for deferral orders when this issue has been resolved. With respect to the issue of the Boreski raised regarding owner-occupied premises, that there was comment on by the board as to the utility of requesting this information, but that in itself was not a grounds for denying the deferral order in that particular case. It is, in fact, they indicated it's questionable why you even need this information. And we did get into a bit of a discussion on that. And the assessor's position was, well, there is no rental income, but there are expenses, so we still do collect the information. But at the end of the day, it was more of an observation than anything. It was not a grounds for refusing to grant the deferral order. I don't think anybody is suggesting that the assessor doesn't have the right to request this information. I will comment briefly as well on Mr. Boreski's line of questioning regarding what's included in the next general assessment, that being the realty, business, and personal property assessments. That issue was fully argued and canvassed in the Manitoba Hydro decision. It was the assessor's position there that one has to read into this mailer the fact that within Section 9.1 of the Municipal Assessment Act, that would also potentially include the business assessment. That argument was not accepted by the municipal board, and I think for good reason. If one is going to be relying on this mailer, it is incumbent on the assessor to make it very clear what it is they are asking for and for what purpose, specifically that being both the realty assessment role and the business assessment. That clearly has not been done on the mailer. It can be easily remedied going forward for the next cycle. So, as I mentioned, and I'll just conclude with this, this issue did come up earlier this year, or I should say in 2020. Mr. Neufeld and I had two cases, one being at 1717 Waverly and the other at 959 Corden. And those board orders should be before you. I think they were provided to the board in advance of today, so you should have them. Obviously, there's not a lot of information contained in them, but what you will see, they're both business assessment cases. Both of those cases, the assessor requested the deferral order for non-compliance. We had the same discussion as we are having today in light of the decision in Hydro. The board considered the Manitoba Hydro decision, and you will note that in both of those cases, the Board of Revision denied their request for a deferral order, and I would suggest appropriately so. So if we are looking at consistency and fairness in terms of the consistency of this board issuing decisions on this issue, and following the municipal board, which really was a test case to resolve these issues, the answer to this particular request in my submission should be clear. It is not appropriate for the assessor to ask or request the deferral order in this case. So with that, I am certainly open to questions.
Thank you. Mr. Forger, any questions?
If I may just have a quick moment. No, thank you.
Mr. Tieran?
Well, I might as well. By the way, Michelle, the emails all came in just now.
Oh,
At 9:52. So, this is incredible. So I'm going to go on what James had to say here. Just want to confirm a few things for me because I was trying to listen as well as I could. So the IE was not a request for each roll number. I'm just trying to confirm that I got everything right here. So there was no, the Manitoba Hydro decision, there was no business assessment roll number. So it was not clear it was for the business. I think that's what you mentioned. And they also say, you also mentioned the mailer is identical in form for both. So it was, in this case, it was strictly the roll number for this property and not the 759 St. Mary's Road. So that created, again, some confusion as to what the request was. So your position is that it doesn't apply.
That's correct.
Did I get this correctly? Because I don't want to look at all the stuff now that I have.
I think you fairly summarized the submission.
Right, okay, and as I mentioned, I've relied on my colleagues, but now I can look at the document later. Thank you.
Thank you. Mr. Boreski, questions?
Thank you for your sort of the reference to the questions that I had made and the information that you then provided. Is there, on the part of the municipal board, when they decided that the reference to general assessment in the letter was insufficient and the roll number reference was very specific just to realty, did they make that decision on the basis of, is there a general rule in law that the specific overrules the general or something like that? Or was this a pragmatic decision where they said, look, that's just too oblique a reference, and you're really only talking about the realty here. And so that is why you should put weight on this argument that general assessment includes everything.
Right. Yeah, I think you have to go back to the initial submissions, but in effect, it was, I would categorize it as in some ways as a fairness argument. And when you're looking at legislation like this, and the resulting penalty to the taxpayer, if there is a finding of non-compliance, there is a heavier onus on the city assessment department to be quite clear in what it is that they are requesting and the purpose for which it is requesting that information. To expect most business owners or owners of property in the city of Winnipeg to do the micro analysis as we are capable of perhaps doing as to what is meant by Section 9 of the Municipal Assessment Act, and to put the logical conclusion or the put two and two together to say, well, this may also include the business assessment. That just wasn't sufficient for the municipal board. And the form on its face was just simply unclear and insufficient. So I think weighing all of that, they just said this form isn't good enough. It can be easily rectified, but on the facts of that case, they said this was insufficient. And as I said, I think this is a matter that can be easily rectified going forward. So it shouldn't be an issue that I think the board or the assessor or taxpayers in the future will have to grapple with, depending on how the assessor sends out these information requests moving forward.
Okay. I'm going to dance on the head of a pin here a little bit, but with it. The fact that one requires specific identification of the roll number that this is to apply to, very specific reference to which role it is to apply to, does that have any bearing on what the information is that is provided? Would it not be the same information, regardless of whether the city had specified both realty and business assessment here?
Well, there would be a separate business assessment for the other occupier, correct? So the salon would have.
Looking at this one application like we have here.
Right.
Whether two roll numbers on this or only one, isn't it the same information?
It could be, depending on if the tenant has different expenses or other income that they're generating in there. But it arguably could be the same.
All right. So then if regardless of what roll numbers are provided at the top of the page, it's the same information that is being sought, there has to be truly the legislation assumes that there needs to be some protection of the individual. They're divulging their economic information, their financial information. Why is it really that important that the city specify both roll numbers at the top if it's the same information in the end anyway?
Well, they have to be clear as to what they're asking for and the purpose for which they're asking for it. So whether the information is identical, and I'm not sure it would be necessarily if there was another, the tenant had its own business assessment, which the salon presumably would. They may have other expenses or income that's reported differently.
Well, Grant, I'm just talking about this one specific case.
Right. Well, there is another occupant in this property, right, being the salon. So in any event, I can't really speculate as to what information at the end of the day would be provided. You might be right, it would be the same. But the point is they have to be very clear for the purpose for which they're asking for the information. Remember, there's potentially two penalties that could be applied here if they're appealing the realty assessment and the business assessment. And it's a bit of a double whammy if you fail to if there's finding a failure on both. And you have to take that into account. And so if you want the penalty on both, and if you want the city wants the benefit of the penalty on both, then they have to be absolutely clear as to what they're requesting. And so the fact that the information might be the same.
You're saying the lack of clarity is the purpose for which they're requesting it, correct?
I'm sorry, could you repeat that question?
It is very clear what they're asking because they send the form. You're arguing, though, aren't you, that it is not quite so clear what the purpose is of asking for that information?
Right.
Okay. So now the assessor has said that there are multiple ways in which they make use of this information.
Mm-hmm.
For instance, determining market rents, market vacancies, all this sort of thing. Would you argue that they would have to specify those uses that the information would be put to as well?
Well, if you actually look at Section 16 of the Municipal Assessment Act, it says that they may I know what they use it for, but the Act actually says that the purpose for which they request information is only for the assessment of the property, not assessments at large. So the property. And that's perhaps a different discussion. But if you look at the Act, that's what it says. It doesn't say for the purpose of making a general assessment of all properties. It says the property. So I come back to, at the end of the day, they say here in their information request, I think somewhere on the form, they indicate that there may be penalties under the Municipal Assessment Act. I'm just trying to find it. And I know there's been mention of that. So if what they're saying is, if you don't send us this information, there could be penalties under the Municipal Assessment Act. I just think, given the nature of the penalty that they're requesting, they have to be absolutely clear the purpose for which it is being requested. That just goes hand in hand. It's a fairness argument, frankly. And an appropriate notice. The taxpayer has to be notified as to what it is they're receiving and for what purpose. And that was fully canvassed by the municipal board. And a determination has been made. The city chose not to appeal that decision. And that's where we're at today.
Okay. Madam Chair, do you mind if I point a question to the assessor?
Yes, go ahead.
Since the Manitoba Hydro decision came out, has the city changed its practice and included roll numbers for realty and roll numbers for business assessment on the information requests, or has it had the opportunity to do so yet?
It has not. We have not included business assessment roll numbers. And the practical reality of doing so may not be such that it's feasible. So, for example, if you look at malls or properties with, 25, 50, 100 tenants, each with their individual roll number, that presents challenges to keep that current for the mailer, to have the owner be able to understand what each question, each roll number is specifying in terms of the business assessment. And for us to be able to, in cases where it wasn't completed properly, for us to then reconcile that information in our system to ensure that we have the right business assessment roll number for that information, I would speculate would be cumbersome. It has not been done, and I don't believe that there are plans within our department to do so. And if I may take the opportunity just to comment on some of the questioning with Mr. Mercury, the information indeed would be the same on a mailer if we had the business assessment ID numbers included on a tenant verification page, or we didn't. It is correct to say that the information would be the same because we're asking for the rental rate. So that should be the same in either case. And we're asking for the expenses for that unit, which would be the same. And so any expenses that may differ wouldn't relate to the operating of that unit or the property, really, truly. Because what we're asking for are, utilities or recoveries, essentially, recoveries for property taxes, for common area maintenance, things like that. So the owner and the business owner should have the same information on what they spend for their unit. And the property owner would have that information for their tenants as well. If the tenants paid utilities themselves, then they wouldn't include that. So there may require some careful filling out if it was submitted by a tenant specifically, but that information ought to be the same.
At the municipal board, did the city argue that doing a practice other than its current practice would be impractical, as you have described in the case where there would be many business roll numbers associated with a property, yet a single realty roll number? Did that get presented?
I don't know that it did. I don't recall reading it in the order.
So, I was part of that, obviously, but I don't recall, to answer your question, I don't recall specifically in that case whether they made such an argument. I certainly have heard that argument on in various other contexts that it's just impractical for us to check certain things, which frankly I'm troubled by that submission because it's never an answer in law, and particularly when we're dealing with fairness issues. That we may not have got it right, but it just you can't ask us to do that because it's too cumbersome. This is and I've said this many times, the penalty, the deferral order that is available to the City of Winnipeg Assessment Department, the City Assessment Assessor generally, is very unique in Canada. It is perhaps one other jurisdiction has anything like it, and it is it is a severe penalty to the taxpayer to effectively have their assessment reduced but not see the benefit of it for a year. You don't see it across the country, and if you have that penalty, you have the right to request it. There is a corresponding obligation on the city to do everything to make sure that the taxpayer fully understands what is being asked of it, consequences of not complying, not only on the realty assessment side, but on the business assessment side. And so for the response to be, well, it's just too cumbersome administratively for us to make it clear, that is an unacceptable response from my perspective. Frankly, in the hydro decision, we raised not on this specific issue, but there was also an issue there as to whether the mailer went to the correct mailing address, and the city hadn't followed its general protocol, but made the submission. Well, it was signed by somebody, and we don't know who it was. This is a bit of a different issue. And one of the submissions was, well, it's just too difficult. We didn't have time to look into it or check whether we sent it to the address that the owner had requested us to. And the municipal board didn't accept that. So there's a fairness obligation here on the city assessment department. And the answer that it's just administratively too difficult is very troublesome from my perspective. it's never been an answer in law to a question like this.
So you're saying that the impracticality is not a valid argument, is no more impractical than having to provide a long list of the business assessment roll numbers, which might be long in the case of Polo Park, but
Right.
so what?
That's a rare exception in Polo Park. I can see they have a laundry list of businesses, but I mean, the vast majority of these assessments are coming out. You're not going to have that issue. Like here, we would have.
Okay. Then back to Mr. Fougere. The municipal board, as has been submitted here, the board of revision has made a couple of other orders where the request was denied. Have those orders been appealed?
I have not verified that. To Mr. Mercury's point earlier, we have not appealed the hydro business assessment order that we've also been referencing. We have not appealed that further. I don't know that we would therefore appeal those border revision orders that denied us the penalties, but I have not looked into those specifically.
Okay, so you haven't appealed them, but you're going to keep asking. Sounds like we'll be going round for quite some time then. We have had the benefit of the legal acumen of the applicant today. Why has there not been a lawyer beside you today?
I can't answer that. I think that our understanding of this is that this order, mentions that we have the ability to request the penalties, and we have in the past, and we have not found it to warrant a revision of our policy with regards to asking for the penalties on the business assessment. And any decision making beyond that, unfortunately, I have difficulty speaking to or for individuals making those decisions with regards to resources such as a lawyer to accompany myself.
Okay, that's all my questions. Thank you.
Madam Chair, could I ask, or I'm raising a point. I wonder if I can do that.
Go ahead.
Can you hear me?
Yes, go ahead.
Okay. I know that the issue before me is non-compliance, and the evidence, we have to make a decision on that evidence, but the result is also a punitive issue, and I think James has raised it to some extent. But I was interested in knowing, is it so that, I know it's a little tricky. My question may be a bit out of line, but I always like to know, depending on the decision, we hit the taxpayer very hard, or was it nominal, or I don't know if I can get an answer, but I know it's been raised before by appellants when they make their case that the penalty is substantial, and that should be taken into account, although I'm aware that it's the evidence we have today before us that has to make the decision on non-compliant. I don't know if there's an answer or not, but I'm just raising that.
So if I could just address that briefly, there's no doubt in certain cases the penalty order will be a very, very significant number depending on the assessment at play and the amount of reduction, if any. In hydro, it was potentially going to be significant. In other cases, not so much. This case in particular, we're in the, relatively speaking, we're not talking about a a case where there are tens of thousands of dollars in at issue, but that's not the point. Frankly, the reason Mr. Neufeld asked me to be here on this, relatively nominal business assessment case, which should be resolved in relatively short order, is not so much the dollar value at issue, but the larger principle at play, and to try to get some resolution on this issue for, going forward, and to seek hopefully some clarity. And so we do have some concern with the assessor's information. This is no criticism of the assessor who was here today at all. I think he's been quite forthright, frankly, in terms of why he's here and the reason he's requesting it, and that is the direction of the department. We do have concern, though, that notwithstanding decisions that have been made by the municipal board and the board of revision, that it's just business as usual, head down, and we're going to continue to ask for it. And we have continuous, we have resources that are being expended on this time and time again, and we're hoping that, frankly, the hope was with the hydro decision that we would not have these continuous debates before the board of revision. That was the whole point of that decision, so that we wouldn't have cases like this, that we could settle the ground rules, so to speak. And so hopefully, perhaps with this case, and maybe some internal discussion at the board of revision level, that we can short circuit these going forward.
Well,
Thank you, Madam Chair. Thanks.
my response to that?
Yes, go ahead, Mr. Boreski.
We are at the mercy of the assessor's request. And if the assessor is going to make the request, then each and every one of those instances, we have to make sure we have sufficient argument brought forward so that we can make an informed decision. So I guess it really is dependent on the assessors.
And I think that's a fair comment from the board. There's obviously an independent obligation to consider each case on its own. With that said, and so we are very much reliant on the assessor and what position they want to put forward. With that said, though, it shouldn't take very long to determine whether the mailer at issue is identical to what was issued in hydro, and if that was unacceptable there, what differentiates that case from this one. And so I think there is a way we could probably speed up this process. But I agree that the board has an obligation to hear the parties. But to the extent we can expedite it, hopefully, maybe we can improve things going forward. That would just be my suggestion.
Thank you. I have no further questions, and at this time, we're just going to take an adjournment. Thank you.
Thank you.
Or a break. Yep. Are you doing? I'd like to call this meeting back to order. Welcome back, everyone. And the board has had time to deliberate and make a decision, and we are going to deny the non-co-op. So, Mr. Porcher, if you would like to start us off with the BM.
Sure. I just wanted to ask you guys if your video is working.
Yes.
Because
yes.
my video is not. But as long as you can hear me.
We can see you. Yeah.
Yeah. Oh, okay. Unfortunately, I can't see you guys, but regardless, I think that's okay to continue on. So now that we've dealt with the request for penalties, we'll move on to the assessment. Again, business assessment 43354, address is 761 St. Mary's Road. I actually have a recommendation here to use $15 as the base ARV per square foot, plus the occupancy costs. And that works out with rounding to 39,720 as the ARV. And that's our recommendation.
Trying. I'm talking.
Mr. Neufeld?
Mr. Fougere and I discussed this in advance, and we are in agreement with the value.
Okay, thank you. Mr. Boreski, any questions?
None.
Maurice, any questions?
Oh, thank you, Madam Chair.
Okay, so we are in agreement at 39,720,
Correct.
correct? All right, thank you. Then this meeting is adjourned. Thank you all very much for your time.
Thank you all very much as well.
Great. Thank you. Appreciate it.
Thank you. Take care.
Have a good day.